Hello and welcome. My name is Kim Ventarola. I'm the president and co-founder of the Milan Syndrome Foundation. I will be your host today. Before I introduce our presenter, I want to point out the Q&A option at the bottom of your screen. Feel free to use this option to ask a question at any point of the presentation, and we will try our best to answer all questions at the end of the presentation. It is now my pleasure to introduce Marisa Lepore Hovanec. Marisa is an attorney in the state of New Jersey and a partner at the boutique family law firm of Gomperts, Penza, McDermott, and Von Ellen LLC, where she focuses her practice primarily on family law of all types, as well as guardianship and planning for children with special needs and their families. Prior to entering the private practice of family law, Marisa served as law clerk to the Honorable Anthony F. Picheka, Jr., Superior Court Judge in the Somerset County Division Family Part. Marisa is a member of the Family Law Executive Committee of the New Jersey State Bar Association. She is also an associate managing editor of and regular contributor to the New Jersey Family Lawyer, New Jersey's premier scholarly publication on family law. She has been selected by the New Jersey Monthly Magazine Super Lawyers edition as a rising star in family law in the years 2015 through 2021, and has been selected a super lawyer for the 2022 publication. In 2020, she was elected by New Jersey Law Journal as the new leader of the bar. We are honored to have her present for us today. So without further ado, I'd like to welcome you, Marisa, and you can take it away. Let me make sure you can.
Okay, sorry. we had some unmuting complications.
So sorry.
Thank you so much. My name's, as Kim said, my name's Marisa Hovanec. I'm a family law attorney in the state of New Jersey. I also do a lot of guardianship work, and frankly, that is where my heart is. I love doing guardianship and doing any type of law that relates to assisting children and parents of children with special needs. So the presentation that I'm going to do for you today is going to be about guardianships / conservatorships, depending on what state you are living in. It depends on what they call it, and we'll get into that. And then also I'm going to touch upon special needs trusts. I want to start with the caveat that a lot of what I'm going to say applies in New Jersey. It may apply in various forms in other states. I have no experience with or knowledge of any international law, but if you, I think this information will help anybody who is the parent of a child with special needs start to become aware of things that they just need to put on their radar. And it's easy enough if you know of something, such as if you know to ask the question, do I need guardianship and how do I get it? Then it's easy to put you in touch with someone who can answer that question for you based on the laws and the rules and regulations in the specific place where you live. So that being said, let me see here. Okay, so I'm going to start, I don't really even need to get into this. Kim did a great job of providing an introduction. I do practice primarily in family law, including divorces, and I do guardianships as well. I'm a partner at the law firm of Gomperts, Penza, McDermott, and Von Ellen in Springfield, New Jersey. So getting right into the substance of the matter, what is guardianship? The definition of guardianship can vary from state to state, as I explained. In some states, like New Jersey, guardianship is the umbrella term for the legal right being given to a person to make decisions, both financial and personal, for a person who has reached the age of 18 and is incapable of making those decisions for themselves. And in New Jersey, we refer to that type of person as an incapacitated adult. And just for ease of future reference and brevity, I'm going to refer to that person as an incapacitated adult moving forward in this presentation. In some other states, guardianship, either there is no such thing as guardianship. In that state, it might be called something else, such as conservatorship, or in some states, they have conservatorships and guardianships are coexist. And in some of those states, guardianship refers to the ability to make decisions of a personal nature for the incapacitated adult, while conservatorship is reserved more for the financial decision side. So again, in every state, you're going to have some slight variation. But if you go to an attorney in any state and say, how do I obtain guardianship for my child? They're going to know what you're talking about, and they're going to point you in the right direction and provide you with the right verbiage for your particular state or jurisdiction. So just touching on then, what is conservatorship? Like with guardianship, it's kind of going to be a synonym, but vary slightly from state to state. In some states, conservatorship is just the same thing as guardianship, just another way of saying the exact same thing that we would call guardianship in New Jersey. In other states, like I said, it can be more specifically toward financial decisions. And then in some other states still, such as California, conservatorship is going to refer to both, just like in New Jersey, both personal and financial decisions. And of course, the most clear example in the news these days of a conservatorship, which would be essentially a guardianship in New Jersey, is what has been imposed upon Britney Spears and what she's been fighting to be released from. I think that the news coverage of Britney Spears's conservatorship has sort of given it a little bit of a bad connotation. There's no reason for that. Of course, in any state, it's not really appropriate to put someone in a conservatorship or a guardianship if they don't actually need it. And that's really the big question in the Britney Spears case. But assuming that the person does need it, and we'll get into what type of person does need it later, assuming that they do, it's a good thing. It's not intended to be, some overarching authority and strict rules constricting the person who is the subject of the guardianship. It's intended to be a helping tool. And again, we'll get more into what guardianship is and what in a perfect world it looks like, but just trust that it's not a bad thing. It's intended to help and not hurt the person. Okay, and so just adding, based on what I said before, that in some states, conservatorship can have different definitions, but for purposes of this presentation, I'm really just going to refer to conservatorship and guardianship interchangeably. One thing I want to point out, jumping off of my point before about a guardianship and a conservatorship really should be reserved for people who really need it. Most states will allow you to have what's called a limited guardianship or conservatorship. So in other words, if you have an incapacitated adult who lacks capacity in certain areas but not other areas, then you can ask the court to institute a guardianship only on the areas where they lack capacity. Again, going back to the fact that the court's goal here is not to take away rights that the person is capable of using properly, but merely to protect them from predatory financial situations or from not being able to make appropriate decisions for their own health, safety, and welfare. And so examples of ways that you can have a limited guardianship or that you can limit the conservatorship or that if you have an adult who is incapacitated for purposes of managing finances, maybe this person just has a serious issue with being able to understand numbers and counting and things like that, that you would be concerned about, like I said, predatory lenders or being taken advantage of financially, but maybe they for whatever reason, are perfectly capable of maintaining and making decisions that are in their best interest for purposes of their health and education. You can carve that out. One right in several guardianships that I've done in New Jersey, we will carve out the incapacitated person's right to obtain a license, a driver's license, or to vote. But I do want to add that particularly in New Jersey, I can't speak to other states, but in New Jersey, just because a person has a guardianship doesn't mean that they can't vote. So it is not necessary to carve that out, although some people like to, just so that they can show the child, yes, you have the right to vote. So that brings me, I touched on this before, but I just want to make sure that it's absolutely clear that the purpose of this presentation is to be general information. I'm not providing you with specific legal advice because it would not be possible for me to do so based on the fact that the laws and the terminology for the subjects that we're going to be talking about vary greatly from state to state, and of course from country to country. And also the individual needs of your child are going to vary. And so, like I said, some people might only need a limited guardianship. Some people might need a full guardianship. Some people might not need it at all. And so this isn't intended to provide you with specific legal advice for your child. And so that being said, from here on out, again, for brevity purposes and efficiency's sake, I'm just going to call both guardianships and conservatorships guardianships. But they're, like, as I explained, they're not exactly the same, but I'm just going to say guardianship from now on, and you'll know what I mean. So when is a guardian needed? A guardian may be needed when an individual is over the age of 18 and incapable of managing all or a part of his or her life, most often as a result of mental or physical disability, alcohol, or drug addiction. There can be different types of situations where a guardian is needed. In the case of a child who has a developmental disability and never achieved capacity, even though they reach the age of 18, you're going to want to get the guardianship implemented basically as soon as they turn age 18. So in other words, if the child's 16, 17 years old and they're going to school, and for whatever reason, whatever the diagnosis, it's clear that the prognosis calls for the fact that they are never going to be able to make those types of decisions for themselves, then you're going to want to get the guardianship basically as soon as they're going to turn 18, so that you retain the right consistently over the course of the child's life, despite them reaching the age of legal majority. Then there's other situations where maybe it's not a case of developmental disability. Maybe it's an onset of the disability came later. So in other words, maybe the child turned 18, or maybe it's not a child. This could be a parent or an adult of any type. Maybe they developed an addiction later in life. And so from age 18 to whatever age, they had no problem making those decisions for themselves. But for whatever reason, whether it's injury, accident, or addiction, or a late onset disease or mental issue, then it may be necessary later in life for that person. When is a guardian not needed? This is kind of the most common question that I get as someone who practices often in the area of guardianship. There's a lot of confusion about power of attorney and how that relates to guardianship. Just because a person has a disability, they may not need guardianship. I don't think it's necessary for me to explain to you that if a person merely has physical disabilities and not mental disabilities, then it may not be necessary. As long as they have the capability to understand the nature of their decisions and the consequences of those decisions, they don't need a guardian. It has nothing to do with your physical capabilities. It's all about your ability to appreciate the weight and significance of different decisions that one would make for themselves. And then, so in the situation though of this more specifically pertains to adults or people who for a period of time had capacity and later lost it. If a person has a power of attorney that was in existence prior to them losing capacity, so in other words, if we're talking about an elderly parent or something, and they have Alzheimer's, but before they developed the Alzheimer's, or before it became an impediment to them understanding what they were signing, if they signed a power of attorney, it may not be necessary to have the guardianship, because you already have created the legal right to make the decisions for that person. And it may not be so necessary to also take away that person's ability to make the decisions for themselves. Because maybe they're in a nursing home, or maybe it's just not a high risk that a predator of any type is going to come and influence them into making a decision that's not in their interests. But coming back to that point, the main difference, sometimes parents will come and say to me, can I have my child sign a power of attorney, thereby alleviating the need to have a guardianship? And my answer to them is no, for two reasons. Most specifically, the argument is if they never had capacity. So if in other words, since birth or since a young age, they've been diagnosed with a developmental disability that impairs their decision making so much that you now feel that they need a guardianship, then they never had the capacity to sign a power of attorney. And if it were to come up, if someone were to challenge that power of attorney on the basis that the person never had the capacity to sign it in the first place, it would become void, and you would be right back in the situation where this person is able to make whatever decisions they want for themselves, whether they're good or not. Secondly, jumping off of that point, when you have guardianship, there are two things that it does. Number one, it preserves or creates a right for the parent or whoever it is who's seeking the guardianship to make the decisions for the incapacitated adult, but also takes away the incapacitated adult's ability to make decisions for him or herself. A power of attorney does not do that. A power of attorney, in essence, creates a second person who can make decisions for the person, for the incapacitated adult, whereas the guardianship takes away that incapacitated adult's ability to make decisions. In other words, just like if you were a child under 18, the incapacitated adult would not be able to enter into legal contracts. If they were to apply for a credit card, that credit card would not be valid because they never had capacity to sign up for it. If they were to go buy a car without their supervisor knowing, then that contract to buy the car would be void, because it would be as if they had sold a car to a 12-year-old. And that is a very valuable tool, particularly to parents of children or adults who feel that that the child would be subject to negative influences, such as people who were not looking out for their best interests. Another important situation is that if you have guardianship, you would retain educational decision-making for your child, whereas if you didn't have guardianship and your child turned 18, even if the school district technically said they could continue to attend until they're 21, like in the state of New Jersey, if they're over 18, if the child's over 18 and you don't have guardianship and they don't want to go to school anymore, there's nothing you can do to legally make them. Similarly with medical decision-making. Over 18, a child's medical decision making will trump the decision of their parent unless the parent has guardianship. And if we have time, I'm going to give you a cautionary tale about medical decision making and guardianship, but I'm not going to do it now because I don't want to use up all of our time speaking about that. This slide is kind of just talking about what I was just saying. Entering into legally binding contracts, making medical decisions, making decisions about their education. All of these rights automatically are imparted upon a child upon reaching the age of 18. Even though they have a developmental disability, they are still considered by the pure fact of them reaching the number of 18 years old, they are now considered an adult who is capable presumptively of making decisions for him or herself, and those decisions, unless a guardianship is in place, will be legally enforceable, whether they're in the child's best interest or not. And again, this is just pointing out what I already said about how if your child has their own decision, own impression about what they want to do with their education after reaching the age of 18, then their decision is going to be legally enforceable, regardless of what you feel about the appropriateness of that decision. And so essentially, just to sum up what guardianship is and why it's needed, it's that having a guardianship will preserve the status quo. It will be as if your child is still under 18 and you are still the parent. You will have all the same rights and protections as if your child was still a child under the age of 18 if you have guardianship in place. Who can be a guardian? Generally, a close relative or a person with a close relationship to the child who will act to protect the child's best interests can be a guardian. Most often in my experience, because I deal with a lot of parents of children who are just reaching the age of 18, most of the time it's going to be the parents or one parent, but grandparents can do it, siblings can do it too. That isn't like probably the second most common question that I get is, can I have guardianship with my other daughter? Like, let's say there's another child and she's 25 and she's not developmentally disabled, some people will have a joint guardianship with their adult child. I generally recommend against it, but I do, in terms of, I generally recommend against there being a joint guardianship between two individuals other than a husband and wife, just because of the risk of people not agreeing on what the appropriate course of action is. And so what I suggest in that event is to simply, instead of having joint guardianship with your child, the other child, I would rather recommend that you in your will say that you would like for that child to be your successor guardian. And that does make it a little bit easier when it comes time, if you were to pass away, when it comes time for that younger child to assume guardianship, he or she will have a much easier time if he or she has already been essentially the chosen one by the predecessor guardian. When there's no close friend or relative available to be a guardian, which is obviously a very sad situation, the court can appoint an attorney or another person to serve as a guardian. And like I said, more than one person can serve as co-guardians. I usually recommend against it unless it's a husband and wife. However, I definitely don't recommend having more than two. All right, so what is the process of obtaining guardianship of a special needs child? Now, I want to remind everybody that this is going to be different in every single state and definitely every single country. But I'm just going to give you a brief rundown of what it looks like in New Jersey in hopes that it might be similar in your state. And when you identify an attorney to assist you in your state, you will have some familiarity with what the process might look like. So in New Jersey, the guardianship application starts with a formal application to the surrogates court in your county. And that application is going to include, most importantly, an affidavit signed by the person seeking guardianship that says, among other things, his or her relationship to the child, the nature of the child's disability, and also provide a list of the child's income and assets, which the court is going to find relevant, mainly because they want to make sure someone's not seeking guardianship just to take advantage of the person's financial circumstances. Also in New Jersey, it's generally, there are some exceptions, but generally it's going to be required to have two affidavits of the child's treating medical doctor or psychologist to confirm the diagnosis and the child's need for a guardian. There are, like I said, other alternatives. For example, in New Jersey, we have something called the Department of Developmental Disabilities. And if your child prior to reaching 18 is already receiving services from that department, then sometimes an affidavit from the Department of Developmental Disabilities will be enough, or alternatively, sometimes an IEP will be enough to demonstrate at least a portion of meet a portion of the requirements. And so in your state, it may be helpful to look into whether there is a similar sort of shortcut for children who are receiving services from the equivalent department in your state. Once the court has received your complaint for guardianship and the affidavits from the physicians attesting to the child's need for one, then in New Jersey, what they're going to do is appoint another attorney. Even if you have your own attorney, the court's going to appoint an independent attorney for your child. And that attorney's job is going to be to interview the child, interview you, and to tell the court whether after interviewing all of you, it thinks that the child does actually in fact need a guardian, and whether you as the proposed guardian are suitable. I will say in the state of New Jersey, I have never had any attorney appointed for the child even remotely question whether the parent filing the guardianship application was an appropriate guardian. I think if you're in this seminar and you care that much about your child, you're going to be approved. So that's not something that you need to worry about. But assuming all of that is clear, the attorney is going to notify the court and essentially recommend that the guardianship be established and that the parent or the person applying for guardianship be appointed. And assuming that occurs, then the court in New Jersey most often won't even make you go to court. They will just sign an order appointing you as a guardian of your child. And that's essentially it. In New Jersey, the guardianship application process can take probably 1 or 2 months, I would say, at a minimum. So I usually tell most people to start thinking about it at least a year ahead, and then maybe consider at that time having a consultation with an attorney in your area to make sure that you know all of the rules and regulations in your particular jurisdiction. Make sure what you know what you're going to need to obtain, such as physician's affidavits or a copy of an IEP or something like that. And then the application process will probably, though, not occur until about 1 or 2 months before the child reaches 18. I really wish you could start the process sooner. And if you know that if your child's 17 and you know you're going to need a guardianship at 18, it would make sense to me that you should be able to apply when the child is 17 and not have any risk of overlap. In New Jersey, the court can't enter the guardianship judgment until the child has turned the age of 18. And so it can be a little bit of a dance trying to determine how far in advance can we file, and also there be enough time, or I should say, there should be the window should be small enough that the court's not going to say, hey, you filed this way too early because your child's still a year from turning 18. Okay, so that was all that I prepared on guardianships. If anybody has a question about that, feel free to put it in the chat. Otherwise, I'm going to move on to special needs trusts, and again, just come back to the cautionary tale about guardianships only if we have time at the end. Okay, so special needs trusts. Again, I will say that special needs trusts and the rules and regulations on them are probably going to be more similar from state to state than the guardianship process, simply because a lot of special needs trust planning has to do with federal departments. Most people, the only reason that they would want to set up a special needs trust would be to preserve their child or the incapacitated person's ability to qualify for Social Security income and Medicaid. That's really by far the most common reason that someone would want to set up a special needs trust. And so for that reason, because SSI and Medicaid regulations apply across the entire country, most of the time special needs trust formation and requirements are going to be somewhat similar from state to state. They're not going to be identical. And again, I do caution you to consult with an attorney who specializes in special needs trusts in your state or jurisdiction. But otherwise, again, this is intended to be general information that should give you some idea of what we're looking at. So like I said, special needs trusts are a trust, just like any other trust, but it is established for the specific purpose of allowing a person with special needs to possess and accumulate assets without compromising his or her ability to qualify for needs-based governmental services, which would include Social Security income and Medicaid. And so by needs-based, I don't mean Medicare or Social Security disability benefits. I just mean essentially welfare type services, services that are based on the person's need and lack of income and ability to provide those services to him or herself. In order to be effective, the funds in a special needs trust, I want to point out, have to be used in a very specific way. So the second point of special needs trust is to spell out the ways that the money in the trust can be used for the beneficiary's benefit. And because the purpose of Social Security income and Medicaid is to provide for that person's food, shelter, and medical services, the trust cannot say that the funds can be used for those purposes. So in other words, there can't be any overlap between Social Security, the use of what Social Security income and Medicaid are intended to be used for, and what the funds in the special needs trust can be used for the child. So you have to be very careful and specific about what the trust says it can be used for. And to that point, there's another name, at least in the state of New Jersey. We will interchangeably refer to special needs trusts as supplemental needs trusts. And the reason for that alternate nomer is that because that's essentially what the special needs trust is allowed to be used for, the child's supplemental needs, not shelter, not food, not medical. It is intended and specifically allowed to be used for entertainment, travel, education, and basically things other than food, shelter, and medical that will enhance the child's life. And that's essentially what the special needs trust needs to spell out in order to maintain its status as a special needs trust. Who needs a special needs trust? Most of the time, like I said, it's only going to be individuals seeking to qualify for Social Security and Medicaid. Individuals who are receiving Social Security disability income, SSDI, are not going to need a special needs trust because that is not needs-based. SSDI is based on your work history, sort of like Social Security retirement income. And so you can receive Social Security disability income and also have other income, and it won't affect your qualification for Social Security disability income. But the difference between Social Security disability income and Social Security income, which a child with a developmental disability will only qualify for, is that because Social Security disability income is based on your work history, someone who never worked is not going to qualify for it. So that's why the only option for a child with a developmental disability who never worked and needs some type of government assistance will only qualify for SSI. As far as those who are looking to qualify for SSI and Medicaid, you really, another reason, like you might not need one if you never expect your child to have more than $2,000 in assets in his or her lifetime, and or if your child doesn't receive, if there's no child support received on behalf of your child, and you never really expect your child to have any significant income. Like I said, a child will be completely disqualified from receiving SSI or Medicaid if they have only $2,000 in assets in their name. So, I mean, for starters, as soon as you know your child is going to need those services, you're going to want to take any assets that might be in their name out of their name while they're still a minor and put it into your name or into a different name so they wouldn't be a disqualifying amount. That being said, if it can't be avoided, if the child is going to inherit or already has substantial assets in their name that can't be moved, then you might need a special needs trust. With regard to income for the child, a child can have some income, or I'm going to put child support for the child under the category of income because generally speaking, child support received for the child is going to count as income to the child for purposes of SSI qualification. That being said, they can have some income, but up to the maximum benefit, which right now is $794 a month in SSI, for every dollar of income the child has, their benefit of $794 is going to be reduced by 50 cents. Another thing to point out is that in general, the Social Security Administration considers anyone who's capable of making $1,310 per month as not disabled. So when you're filing the application to have a determination of disability to begin with, if the Social Security Administration finds that your child has a capability of making that much money, then they may not qualify for Social Security income at all. That being said, with respect to the Social Security income, obviously a $794 a month is extra for your child is great, and everybody's going to want that, and everybody's going to need that for their child. But the value of the Medicaid benefits is obviously going to be even much more than the $794 a month that you're going to receive for Social Security income. So even if you don't actually really need the Social Security income, qualifying for the Medicaid, which is going to have the essentially the same qualification requirements as the Social Security income, that's where you're really going to want to be, probably regardless of your income level and assets, unless you're a multimillionaire. Medicaid insurance is going to be invaluable for your special needs child, particularly the group home benefits. If that's something that you think might be in your child's future, will potentially could be hundreds of thousands of dollars in benefit, if not millions. And so even if you're saying, okay, $794 a month, is it worth the hassle? Considering that the same requirements are in place for Medicaid as Social Security income, it's probably something that most people are going to want to do. As far as what are the types of special needs trusts, there are two, and this is very important. So I want you to listen closely. There are two types of special needs trusts. One is called a first party trust and one is called a third party trust. And there's one major difference, which I'll get to, but first I'm going to explain what is a first party trust. A first party trust is a trust that's established by the beneficiary of the trust for his or her own benefit, funded by his or her own assets. So in other words, this would be your special needs child establishing a trust for himself. And when I say that, I don't mean that your child is going to go to an attorney and ask for someone to prepare the trust. Of course, that's probably going to be you. But the major distinction is that the trust is going to be funded with the child's own assets and income. And so I know that's hard to imagine what assets and income the child might have, but one of the most common things is a settlement. If your child was injured at birth, or if the nature of their disability is such that you were able to obtain a settlement for that child's future care, then technically that settlement is probably for your child or was in your child's name. And in that case, it is their asset that would be disqualifying for purposes of future Social Security and Medicaid qualification, unless it was put into a trust. And in that case, since it was at one point in your child's name or for their exclusive benefit, it's going to have to go into a first party trust. Other examples would be child support, because again, at least in the state of New Jersey, and I believe it would probably be the same everywhere, child support received for the beneficiary of the trust is going to be considered income. I mean, I should say child support for a child is considered income to that child, regardless of whether the check is being written to the child's mom or probation department or whatever. It's considered disqualifying income to the child. And so if the child's receiving child support, that would go into a first party trust in order to not disqualify the child from qualification for benefits. A third party trust, on the other hand, is a trust that's established for the child's benefit by someone other than the beneficiary with their income. So if a mom and dad wanted to set up a trust for their child to provide for their future supplemental needs, then that would be a third party trust. If a mom and dad wanted to have a life insurance benefit that went to that child, but they didn't want it to disqualify the child from receiving future Medicaid and Social Security benefits, then they would name the the trust, the third party special needs trust, as the beneficiary of the life insurance benefit. Same thing with a will. Whether if the mom and dad or a grandparent or another family member wanted to leave assets to the child for his or her benefit, but didn't want that inheritance to disqualify them in the future from receiving benefits, they would leave it to a third party trust. So in other words, those assets were never in the child's name. They go into a third party trust. This is where the differences become very important. A third party trust, because it was never in the child's name, when the beneficiary of a third party trust dies or otherwise becomes no longer eligible to collect, someone who sets up a third party trust can name an alternate beneficiary, and whatever money continues to be in the trust upon that beneficiary passing away can be given to someone else, another child, and a charity, whatever you want to do. In a third party trust, you have the ability to provide an alternate beneficiary when that child dies. With a first party trust, which, like I said, is the trust that you would need to establish if this money was ever in your child's name or for his benefit, then all of the money in the trust will be paid back to Medicaid. Not necessarily all, up to the amount that Medicaid paid for the child in his or her lifetime. They can come back to the trust and recapture it, and they will. So in a lot of cases, when you have a first party trust, the goal is to spend it all in the child's lifetime, because otherwise it's gone. It's sort of like, I don't know if you guys are familiar with those cafeteria plans or those health savings type accounts that you can have under federal law. And it's like use it or lose it. It's the same theory. If you don't use all the money in the trust during the child's lifetime, you cannot name an alternate beneficiary of a first party trust. You have to pay it back to Medicaid for all the benefits that they provided over the child's lifetime. So the final caveat regarding special needs trusts is something I've said a million times in this presentation. And it's basically that the rules for special needs trusts, just like with guardianships, are likely to differ from state to state, but they're definitely going to differ from country to country. Because of the very meticulous and specific nature of the language that's required in a special needs trust, it is so critical that it be drafted by someone who has experience with this in your state or jurisdiction. And so I highly recommend guardianships for the most part, at least in the state of New Jersey, they can be done pro se, meaning they can be done by someone who's representing themselves in court. It's very annoying. I would say the process can be annoying if you're not familiar with it. So a lot of people think like, oh, it's not worth it. The frustration of going through the process of a guardianship without an attorney. So I'm just going to hire an attorney. I mean, I recommend that route, but it is still possible if you don't have the money, or if for whatever reason you want to do a guardianship, you want to get that going yourself. It's not the end of the world. It can be done. With a special needs trust, I would definitely not recommend it, because the consequences of getting one word or one paragraph wrong in a special needs trust can be very extreme, in that if you do not use the funds in a special needs trust in the specific way that the government allows, they can recapture it, and you can end up owing the government all the money that you thought you were preserving for your child. Okay, so that was all I had. Do I have time to give my cautionary tale? Somebody just tell me.
Yes.
Okay, all right. So I'll make it brief. And then I see, are there some questions too?
Yes.
Okay, so after I tell my quick story, I'm gonna address your questions. So the first story, and again, this has to do with guardianship, and I think is the most compelling example I can think of for why someone would need a guardianship. And it is that my sister is a special ed teacher in New Jersey. And I became interested in doing guardianships and other types of law pertaining to individuals with special needs as a result of my sister. I also have a cousin with Down syndrome and a godson with autism. So obviously this was going to be my passion project, obviously, to begin with. But I didn't get into guardianships until one of my sister's former students, who had turned 18, ended up in a state psychiatric hospital because he had a mental break. And his mom, like most moms would do, called the ambulance. The ambulance took him to the local hospital. Again, nothing out of the ordinary there, that was appropriate. But once at the hospital, the hospital determined that this child was in need of emergency psychiatric help, but would not let mom have any say in where he would go, because he was over 18 and she didn't even know that she needed to obtain guardianship. And so, like, he was just 18, and she didn't realize that she had no more legal right to say what was going to happen to her child. And so in that situation, even though her child was not he didn't have capacity to make decisions, he was in the middle of a mental breakdown. But the hospital in that situation then determined, okay, we are going to involuntarily commit this person, like they would with someone who was having a psychiatric break, to wherever we deem fit. And ultimately where they deemed fit was a very scary state-run mental institution, where the mom was very nervous about putting this sheltered 18-year-old from Old Bridge, New Jersey. And she, in a panic, called my sister, knowing that she had a sister who was a lawyer. And we were ultimately, thank God, able to obtain emergency guardianship and get him out. But he was still there for like 3 days before we were able to make the wheels of justice turn. And it was a very scary situation. And so, again, just knowing that you need guardianship is half the battle. I'm happy you guys are all here. Please spread the word. Kim and I were talking before we started this presentation about how it does seem that, at least in the districts where I speak to the parents of special ed children more often, the child study teams are tending to remind parents, or at least make them aware even earlier and earlier, that guardianship is going to be necessary down the pike. And I'm really glad about that. But to the extent that not everybody knows, I'm really glad you're here and you will know, and I hope that you can spread the word too. All right, so I'm going to go to the questions. Is that good, Kim?
Yes, if you want to read them yourself, that you go right ahead.
Okay, yeah, I'll just scroll through them. All right. Okay, so can guardianship protect your child if they commit a crime as an adult with a cognitive mental disability? It's not going to automatically protect your child from any type of punishment for committing a crime, but I'm not a criminal defense attorney, but I would imagine that a determination that a child is incapacitated would probably help in their defense for the crime, because it would prove that they didn't have the appropriate mental capacity to form the intent. So as you may or may not know, I mean, I learned in law school, again, I'm not a criminal defense attorney, but I remember from law school that a lot of what's necessary to criminally prosecute someone is their intent. And so I think if your child's been determined to be incapacitated, it would probably be harder for a prosecutor to prove that they could form the appropriate intent to commit the crime. I mean, you might run into issues with, depending on the severity of the crime, and it may not be a defense if intent is not a requisite element of the crime. But again, if you have that determination of incapacity, I would think it would only help you and not hurt you in that situation. But it's not going to be an automatic, get out of jail free card, for lack of a better term. When do you apply for SSI for your child? At age 18. Again, I would imagine it's probably this way in most states. In New Jersey, you could not apply for SSI before they reach age 18. Well, you could, but they would be evaluated based on the income of their parent until they reach the age of 18. So most people who are talking to me are of sufficient means that their income and assets would disqualify the child prior to reaching age 18. After age 18 is when you would apply. What is the difference between a special needs trust and an ABLE account? It's a great question. I wrote an article on this for the New Jersey Family Lawyer recently. And a special needs trust, an ABLE account is essentially like a mini version of a special needs trust. But and the money in an ABLE account can be used only for the same purposes as the money in a special needs trust. The main differences are that when you set up a special needs trust, you can put in as much money into that trust as you want. Like, let's assume for purposes of this example that it's a third-party trust that you've set up for your child. You can deposit as much money as you want into that trust, and it's not going to matter. For ABLE accounts, and forgive me because I don't know these figures off the top of my head, but I believe the maximum amount of money that can be deposited into an ABLE account by anybody, so collectively, is the maximum amount allowable under the tax returns for the gift tax exclusion, which I don't remember exactly what that number is, but like, let's say it's $14,000 or something. That's the maximum amount that would be able to be deposited into the trust. And if you exceed that amount, you may risk disqualification. Likewise, there's a maximum balance allowed in an ABLE account. And I think it's like $100,000 or something. Again, don't quote me on these numbers, but there's a maximum balance on how much money can be in an ABLE account. There's not for a special needs trust. And so those are the major differences. That being said, if you don't have any expectation that there's going to be any danger of approaching or exceeding those limits, sometimes a special needs trust isn't necessary. Sometimes you can just use an ABLE account. But I do want to caution you that, at least in New Jersey, child support paid into an ABLE account is not going to insulate that child support from being counted in the SSI calculation. But it would be discounted if it's put into a special needs trust. Okay, so is limited guardianship similar to supported decision-making? I don't know exactly what you mean by supported decision-making. That might be a terminology from a different state, but frankly, any type of guardianship could be looked at as a form of supported decision making, to the extent that just because you have guardianship doesn't mean that you can't give your child the ability to express his or her opinion as to what he or she wants. And if you don't disagree with what he or she wants, they can have it. Sometimes, I'll be honest with you, sometimes my clients don't even tell the child that they have guardianship. And because it only really becomes a problem if the child is doing something that's going to put him or her in danger. And so, yes, limited guardianship could be, I would imagine, a form of supported decision making, but limited guardianship is more just about the types of decisions that they're allowed to make. So I don't know if that answers the question, but I don't really know if you're talking about a technical term or not for supported decision making. What are the pros and cons of an ABLE account? I think I kind of addressed that, where pros and cons, really the cons are that there's limits on how much you can contribute. The pros are that it's free in most states to establish an ABLE account. So with a special needs trust, generally, because it is so specific and you need an attorney, I think, to establish it, you're going to probably spend thousands of dollars, to be honest with you, establishing a special needs trust. Whereas an ABLE account is probably not going to cost you anything, at least in the beginning. And so it also, to that end, might be a transitional type of vehicle. So if your child's just turning 18 and you're like, okay, how I need to put this money somewhere so it doesn't disqualify him or her from SSI, but I don't have the money right now to set up a whole special needs trust, and I'm not worried about an inheritance that's right down the pike, then you might do an ABLE account and then think about doing a special needs trust if or when any of those things come up. Oh, thanks for whoever said that the $15,000 annual is the annual limit for contributions to the ABLE account. Is there a limit in the amount of money you can withdraw from a special needs trust? I don't think so. It's a good question, and I guess I don't know for sure that I'm right. I don't think there's a limit on the amount of money. Again, it's the limitation is going to be on what that money can be used for. So as long as you're using it for an eligible expense under the special needs trust, I don't think there is. And like, to the extent that you can use it for education. So maybe if your child went to college, you could probably take out, the amount of money necessary to pay his or her tuition. I don't believe that there is a limit on how much you can withdraw. Speaking of inheritance, I would assume a special needs trust would have to be implemented. Yeah, I think that if you expect your child to inherit any amount more than $2,000, then I think it's important to have a special needs trust. One thing I don't know the answer to right now, and it might be worth a little bit of research, is can you name the child's ABLE account as the beneficiary of an inheritance? I don't know the answer to that, but it might be something worth looking into. But again, to the extent that the ABLE account is limited in terms of how much more money it can accept each year and the maximum amount of money that it can have at any given time, I wouldn't take the risk. If you think an inheritance is coming down the pike, or like I said, if you have life insurance benefits that you would like to leave your child as full or partial beneficiary of, I think a special needs trust is your best bet. Okay, I think those are all the questions. So is there anything else I can do for you guys today?
Marisa, I had a question for you. Is there a way you can send me that article that you wrote on ABLE accounts versus a special needs trust, and I can send it out to the families?
Totally, yeah, I'll email that to you right as soon as we're done.
Awesome. Okay.
Yep.
Are there any other questions from anyone in the audience or attendees? Also, we will record it. We will send it out to our Family Connect members. I will also send out the link for that article because I think that'll be really beneficial. This was awesome. I appreciate your time. I'm sure our community appreciates your time. It's a tough subject. It's hard to think about, but I think that it's important, and I think it was really helpful.
Good. I'm glad. I'm happy to come back anytime. And yeah, I'll shoot you the article. Just so you know, the article was written for other lawyers. So it may be a little bit, tough to read. Well, might be
Clearly, it's okay.
like if you can't sleep type of thing, but it does have good information in it, so it's definitely worth checking out.
Okay, great. I appreciate that.
Right,
All
thanks.
right, everyone. We hope you have a great day.
All right, bye.